Welcome back, America. We're here with our friend, top lawyer, Jim Trusty. Jim Trusty, let's step back from the intricacies and the weeds in this case and the legalese. You look at this case, we can sum it up very easily. What took place in there was tyranny. It was rogue from beginning to end, the taking of the case. I don't blame the jury because there should never have been a jury. That case should have been dismissed, period. But all that said, this has a national impact on the voters, on the nation. It has an impact on our constitutional system. It has a federal impact on our federal election laws and federal jurisdiction and federal judicial authority. How do you sum this up? What do you make of all this?
Well, I mean, these are the wages of lawfare. You know, we've if it stands, we're living in a system now where it's okay to announce that you're going to target political figures, to disable them, to destroy their campaigns, and to come up with inventive use of law for that very purpose. And it's just the antithesis of everything rule of law stands for. I mean, just think about this, Mark. This week, we had the incredible spectacle of Michael Cohen appearing on TV and announcing that truth is important. I mean, that's the spokesman, the minister of truth for lawfare is Michael Cohen. That should tell you a lot. So I view it as historic in terms of damage, that this is, you know, as you and I have talked about, this is the Rubicon. It's been crossed. And if it is not undone, then we have forever damaged the institution and the respect for the institution of criminal justice.
Do you think the fact that one state, it's not even the state, that one prosecutor and one judge, now they're saying, well, they sentenced Trump and so forth and so on. They will. The question is to what? Should have this kind of power over the nation in the middle of an election without any real way to address this? I mean, you go up and down the state criminal court processes, appellate processes, and so forth, but this was timed to basically exclude that. In other words, to make it a dead letter. You can do that all you want, and in the end, you know, Trump will be found innocent. That's all great. But the damage, the impact on the nation, the electoral system, federal election law has occurred. So this evil, devious effort will have succeeded. So either there's a way to bring this to the Supreme Court, whether they take it or not, or this is what we have to live with, right?
Well, Mark, you know, that starting point about trying to get Supreme Court involvement, I think, is still a good one. And I recognize it's probably uphill. You've been kind of at the forefront of pushing that argument, and I think it's got potential. But the bottom line is it's nothing ventured, nothing gained. I don't know why. I mean, someone would have to convince me that it's going to be actually a negative to try to pursue Supreme Court involvement. And I will say this to have a little shred of encouragement for that. You know, the Supreme Court, when they dealt with the immunity issue and Jack Smith trying to manipulate the timing of when they would deal with it, they seemed, I think, very cognizant, and this went all the way through oral argument, very cognizant of the idea that lawfare is breaking out around them. They knew the context of what was happening when they made their decisions to either not take the expedited request or to take it and to handle the arguments the way they did. So I don't rule out the Supreme Court getting involved just because of the uniquely historical and perhaps horrible context. And that weaves into the second part of your comments, Mark. You know, the idea that he's going to have this Pyrrhic victory of a low-grade series of felonies, overblown, vague, due process violative felonies being reversed 15 months from now. You know, yes, that's a good ending, but it is justice delayed being justice denied. It's giving the lawfare proponents the benefit of incapacitating him for the trial and for calling him a felon and all the things they're going to do during this campaign when the case is on the flimsiest of foundations.
And that is the problem. The problem is the people who hatched this were quite diabolical. And they were looking at New York state law. The people who hatched this were people first who were outside the government, then they came in to the DA's office. And this was the plan. The plan was to time it in a way where, number one, which they would bog down Trump, so you don't have an equal playing field even when it comes to the electoral process. You've got one candidate who's unfettered, Biden, the other guy who's handicapped. So we, the people, the public, doesn't get to meet, speak to in person, hear from the candidate. Then there's horrendous gag orders placed on him. All these steps are taken because they want an outcome, and that is they want guilty. Now they know, well, you can appeal. Well, great, but you can't appeal in time, and you're also having to appeal in the very state under the very process that is unconstitutional, in my view, as the nullification of the due process in equal protection. That's what took place in that courtroom. These are federal constitutional violations. This is why I think, Jim Trusty, the judge didn't give a damn. That was of no consequence to him. The appeal process, who cares? That'll be after the fact. The damage will be done. Don't you think that's what they were thinking?
Yeah, I think so, Mark. I mean, look, I tend not to go too heavy about any judge unless I'm sitting in court every day and really picking up on some of the more subtle psychology and moments of it. But this case was chock full of error, and that feels like a politicized, reckless kind of approach. And look, it starts with the judge not recusing. You know, I don't really care that much about the penny ante donations. But when the judge's daughter is a high-powered operative in the national level Democratic Party, how hard would it be in New York, of all places, to say maybe somebody else should handle this for the appearance of impartiality? But that didn't happen here. And then you have a series of rulings, including denying the FEC chairman from testifying in the defense. I think a critical due process moment. You're talking about a defense witness, and these kind of vague, unsupportable jury instructions that would allow almost any jury to convict on the facts of this case. So I think there's a whole bunch of issues that need a hard look. Obviously, you want to look to make sure everything's preserved, that there was objections that were made at the appropriate time. But there's a number of violations, both independently and cumulatively, that look to be violations of due process.
Hey, Sean Hannity here. Hey, click here to subscribe to Fox News YouTube page and catch our hottest interviews and most compelling analysis. You will not get it anywhere else.